Good evening and welcome to the January 3rd, 2018 meeting of the Zoning Board of Appeals. Tonight we have one open meeting agenda, which I'll get into in a minute. First, I would like to introduce the board. To my right is Jerry Patamas. He is an associate member of the board. My name is Terrence Hurry. I'm the acting chair for tonight. To my left is Ed Van Kuren. He is a full voting member of the board, followed by Bob Dugan, who is an associate member of the board. And we also have Suri Boudreau, who is the zoning administrator. I usually have a long spiel of rules and everything, but I'll keep it short because half of it doesn't apply for tonight. Tonight is board discussion and a possible vote on appeal number 67-17 Midway Trap and Skeet. The board has reviewed the file. The hearing is closed. There'll be no public comment held tonight at all since the hearing has been closed. I ask the members of the public to please refrain from any comment amongst yourselves at all and to please turn off any cell phones. And at this time, I'll just ask if there's any members of the public or members of the press who intend on recording this at all today. And please state your name and your organization's name, please.
Brittany from Enterprise.
Thank you, Brittany. All right, with that out of the way, we do have the discussion for this appeal. We did have a board discussion about a related appeal. This one is for 67-17 Midway Trap and Skeet. The focus of our discussion tonight will be on the cease and desist order of the building commissioner regarding the pistol range located at Midway Trap and Skeet. Our discussion will be whether to uphold or overturn the cease and desist order. Since there's only 4 of us sitting, the decision will have to be unanimous. In the event that the vote is not unanimous, then I believe the cease and desist order stands. So for tonight, in order to have discussion, I think it would be easier for each member to state whether they're in favor of upholding or overturning the decision, and then listing reasons why. So there'll be findings. And Suri has also requested us to hand in our possible findings to her to help her the best we can. Also, before we start, I just want to acknowledge Suri and also Ashley DeMello, who isn't here tonight. She is the assistant in the ZBA office. ZBA office has done a lot these past few months and looks like we're going strong into 2018 in terms of applications. They've been very busy with these 2 appeals, and they've also been extremely busy with new applications coming into the office, so I just want to acknowledge them and thank them for the help with assisting the public with the phone calls, coming to these meetings, of course assisting the board with the holiday season and all. So we will start with discussion. Bob, if you want to state if you're in favor of upholding, overturning the cease and desist order, and then you can list your findings.
Right, I would be in favor of overturning the decision of the building commissioner. In review of the files, the testimony that the building commissioner gave was in conflict with his cease and desist letter. His letter stated that his conclusion on the substantial expansion of the pistol range was supported by aerial photographs, but yet his testimony was that it was very challenging to use any photos to view the pistol range. He also said that it was supported by a March 2014 survey, but the survey that he used was for a cell tower. It wasn't specific to the pistol range. There are affidavits in the file signed under pains of penalty and perjury, specifically the affidavit of Roland E. Beliveau, dated 10/2/17. On item 5, he did state that he shot his .22 pistol at Midway Trap and Skeet in the mid to late 1960s at the location of the current pistol range. He did mention that there was no berm, but he had also observed others shooting pistols as well. There was also an affidavit of Robert H. Walker stating that the pistol range was in existence in 1972 when he was there, but that his father had shot there since 1970. In the affidavit of Michael Rabisa, He did mention that that berm, as previously stated, to the rifle and pistol range was added, but they did not move either range. They're in the same location. The berm seemed to be a modest safety improvement based on Mass DEP suggestions, and that shouldn't be suggested as a substantial expansion. Mr. Palmer also used just his observations of soils to determine that the pistol range might have been expanded, but there was nothing, no basis in the file to back that up versus just observation. There were also aerials submitted by Attorney George that appears to show a pistol range on the aerial photographs. So based on those, I'd be in favor of returning the building commissioner's decision.
Thank you, Bob. Ed, we'll go with you next.
Yeah, I'm also in favor of, excuse me, also in favor of overturning the decision. And based on the affidavits, which go back to say that the pistol range was active in the 60s, which was prior to the zoning change. And so hence it's grandfathered in. And there was, besides the ones, the affidavits that Bob just mentioned, there was one from John Augusta, Michael D'Souza, Daniel Pimentel, and one more from Walker, I think you mentioned that. So, in going through all the files, it's, to me, it's very obvious that there was activity there in the 60s. And it was, there's people all signed these sworn affidavits under pain and penalty of perjury. So I feel that it should be overturned. And the building commissioner also had raised the question of some of his judgments, even in the printed words that's in the file here. Yeah?
All right. I would be in favor of overturning the commissioner's decision. Bob and Ed, you did touch upon the same affidavits that I was going to cite, but I'll just go ahead just so I'm on the record. The John Augusta affidavit stated that his father shot pistols there in the 60s, the present location where it is located today. The D'Souza affidavit also stated that the shot pistols at the current location. And Ed, you did cite the Pimentel and Walker affidavits, and I think, Bob, you did as well. That does it from me. Jerry?
I guess I concur with the other board members, and I guess I'd like to add in. The notice of prevention of easement states that there's been firing for well over 25 years. And, it mentions the rifle range, the pistol range, outside rifle range and pistol range. And that's dated 1984. Although it doesn't say there were separate ranges, when you read that in combination with the others, I think that confirms what the other board members concluded, and I had also concluded independently. The date of that notice of prevention of easement, the one I'm looking at, is 1984, so 25 years, less than that takes it before. The other thing, and I wrote it down, and I wish I could say the dog ate it, but I don't have a dog. I think Mr. Worley's ground truthing on the photo interpretations, that he had measured both ranges to be 50 feet, and it was also in response to a letter by Attorney Amante, and was also submitted as backup by Mr. George, that would establish that there were two separate ranges there, or the width would accommodate two separate ranges.
Okay. Well, everyone's had a chance to
Can
state
I ask
all
the
their
board
findings.
if there was any other evidence submitted outside of testimony? I know that Member Dugan mentioned a plan that was submitted that was for a cell tower that didn't show anything on the gun range. Was there any other physical evidence that was submitted that you could base your finding on? any of the other aerials, or do you have an opinion on the aerials, if they substantiate anything or not?
I think the aerials can be contradictory depending on the elevation, things like that, and it's hard to make a definitive decision based on the aerials. They were poor quality, I guess. In some, it clearly looked like maybe there wasn't a range there, and I think those were submitted by one side. The other sides, showed where it could have been a range. My own experience trying to think of what a rifle range would look like, and you take it from an aerial, it wouldn't take much to cloud it. So I think the aerial photographs were not convincing one way or the other. It's like the Bible. You could find anything in it that you want. You can strike that comment.
Yeah, I think I will. Anyone?
There was also a comment made by Eric Peterson that, I won't read the whole thing, but there was a question in the building commissioner's mind as to when the pistol range was put there, and it looked like it was fairly recent, but it was, this Eric Peterson said that he'd been going, he would come down here as a kid for turkey shoots, and the right side was always vegetated, and on the left side, there was always gravel, earth coming down, and he was talking like in 1970. That's in here, it's underlined, but I'll give you this.
Is that an affidavit, or was that
No, that was a
testimony?
testimony on the 16th of November.
Yes.
It's underlined, I'll give you this.
Thank you.
Is there anything we didn't cover?
I was just about to ask that. Anything anyone else wants to add?
Well, do you want to, I'll read this. This is Rod Palmer's, based especially on my site visit when I observed the soils and vegetation which was spoken of in and around the pistol range and the berm. Between the pistol range and the rifle range, I determined that the pistol range was constructed in the last several years. My conclusion is supported by aerial photographs and by a survey of the property prepared in 2014, which is the cell tower plan. The pistol range was a significant expansion by Midway with significant impacts on neighbors that should not have occurred absent a special permit from the Falmouth Zoning Board of Appeals under Code 240-38B, private clubs not conducted for profit, or Section 243C, which is your pre-existing non-conforming. Therefore, pursuant to General Laws, Chapter 48, Section 7, and Code of Falmouth 241-79, 180, 184, I hereby order Midway Trap and Skeet to cease and desist from the operation of the pistol range until and unless proper permits therefore have been obtained in accordance with Mass General Laws 40A. This decision and order may be appealed, blah, blah, blah. Do you have any other findings that can add value
I think
based on your decisions and what it appears that you're going for? Because what you're doing is you're overturning his decision.
Yes, I
Now,
think,
you did mention soil conditions, you did mention the plan. Any impact on neighbors? You've got testimony in there from several neighbors. I believe the earliest one that lived there was 1996, if I'm correct, at least that gave testimony.
could we back up just a little on both of those?
Yeah, so
To
you
the
guys go
chairman.
through the chair.
One, it was the commissioner's observation that there was disturbed soil there. I think it was kind of obvious when I went out there. He could not speculate as to when the pistol range was established, just that there was disturbed soil. I thought we were voting on, and I'm clear in my mind, that the pistol range was there in his grandfather. The alterations to the land itself may be a slippery slope, but it's a non-conforming existing use, hasn't been modified. You have a non-conforming house.
Okay, I
You know,
think
you
you need
paint
to-
the house, that's not a substantial change to the use of the house.
Right.
As far as the noise, I guess, do we go into the powers test, and if we accept that the pistol range was there and the neighbors grew around the pistol range, okay? There was no noise for neighbors, but there were no neighbors. As the neighbors increased, you could say they testified that they were made more aware of it. But you could assume the baseline was 0, therefore, you know, so it's hard to measure and how much the increase was, other than a lot of the neighbors focused in and around 2014. And I don't know if that's when they all got together, and that seems to be what I read
Okay.
in this file. I mean,
So do you want to, well,
Should we put it, the date of the berm creation was 2010. So the berm was created in 2010, and they would have been shooting from 2010 to 2014. Their question of the noise is basically 2014.
that's when they said it was increased.
So going by that, the berm shouldn't have really affected anything different because the range was already in existence in that location. The addition was the berm. You would have heard it in 2010. So there may be other factors that have nothing to do with the actual club affecting the noise.
Like the
trees,
hunting
winds,
at
et cetera.
Tony Andrew Farm.
So, yes.
Okay, so,
Mass General Law 214-7
Can protect it.
It protects them for
well,
noise.
what the board, I understand that, but what the board's got to establish, and establish without good question, is that there was a pistol range there, and that's the way you're leaning, that's the way you have said what your findings are. I'm just asking you to make sure that your findings are solid and can substantiate overturning the building commissioner that, in his opinion, there was no pistol range
I
until a
think we
few
have
years ago.
affidavit stating
I would think
there
the
was.
affidavits would count a lot.
And he concludes that he doesn't know what was there. He could only see what he could see. There was,
And the 2010 berm addition for the safety standards would qualify for what he's seeing from soils and growth on top of the berm. But that's a
Okay,
safety.
is that in your finding as well?
Yeah, but that's a safety modification, it's not an expansion.
I think the other thing, and Sari may try to say, cut this out, but there's at least some testimony to say there's no difference in noise when the pistol range was shut down. Now, that was testimony on the other project, but it was, and maybe it was incidental, maybe, I don't know, but there was at least one person that said there was no difference after the pistol range was shut down.
Well, we're going for a preponderance here, so we want credible evidence. And
What?
you're saying that the testimony signed under, or the affidavit signed
Hands in
under,
perjury.
and the fact that the cell tower plan was for the cell tower does not reflect the gun range. Photos can be obscured by foliage.
Yes.
Altitude, a lot of things. I mean,
And
Okay.
there was testimony, at least regarding the sound, that was during a previous hearing, that it could be contributed to other noises around the area, illegal hunting and things of that nature.
do we have to go through, or should we go through the powers test? I mean,
No, because you're establishing, the powers test is a test as to whether it possibly needs a special permit. You're saying through your determination that the pistol range existed.
Yes.
You're not making a determination if it requires a special permit. You're saying that it existed. The powers test goes through the test of, does the use not reflect the nature and purpose, blah, 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 all the other things. What change substantiated? You're not doing that. You're saying you're going to overturn the building commissioner's determination that there was no pistol range there. So the powers
Right.
test,
But if you used it as an educational tool. If you look-
decisions aren't about
Yeah, but we just have to
education.
go-
No, but the three powers test requirements could clearly satisfy our finding.
But if we look just at the building commissioner's determination, he completely contradicted himself with his testimony. It doesn't match his letter. His letter says he relied on aerial photographs. His testimony said he couldn't rely on aerial photographs. He relied on a survey that had nothing to do specifically with the pistol range. So if he had put different criteria to back up his argument, but he's He's not even backing up his argument of his original cease and desist order. It doesn't make any sense.
I mean, I think there's a preponderance of evidence that the pistol range existed.
Yeah, I think there's no
I
question
mean,
about
there's no,
that.
I mean, I think if that's the test, and I guess we don't take into consideration the impacts to the neighbors. If that's how we would interpret
The testimony by the abutters was strictly about noise. It didn't lend to any evidence that a pistol range did or did not exist.
I agree, I mean, although I have
So-
sympathy for the neighbors, and I'm
Of
assuming...
course, of course.
Some of them have been annoyed,
I'm
are annoyed.
not negating that, I'm just saying that that's,
And neither am I, so our
think that's
test
a
is a very
finding.
narrow test. And I think we've all said the pistol range existed.
And they haven't, they haven't also, they have not expanded membership of the club. They've kept it at the, at the single
that doesn't
figure, so-
substantiate.
No, but if you're looking at a pistol range, if you're looking at expansion and enlarging, there's no need.
Then write
Using
that
the same-
down.
No, I think it...
And remember, preponderance doesn't mean quantity, it means the quality of credible evidence.
Well, the quality...
If you feel that you have enough and you've given enough, then there you go, you can make your determination.
I mean, the quality is, and if you won't write it down, I will, but my penmanship's terrible. The membership hasn't gone, if the membership went up 350, it's essentially the same. So without any evidence of increase or decreased shooting, I think that's an indication that the range is at about the same level it always has been, based on membership. And that's the rifle and pistol, not the skeet. So we do full motion?
Do you want
Okay.
to get one more thing on the record in terms of the building commissioner's statement about the berm and the backstop and all that? There is case law that I think is on point. It was Derby Refining, and it was citing Cape Resort Hotels.
I'm sorry, what was the case law?
It was Derby Refining, and it was citing Cape Resort Hotels, which coincidentally happened here in Falmouth. And the main quote to pull out of that is, "The valid non-conforming use does not lose that status merely because it is improved and made more efficient, provided, however, that the changes are ordinarily and reasonably adapted to the reasonable use and do not constitute a change in the original nature and purpose of the undertaking." So I think simply installing the berm, and which was done for safety reasons, and then the backstop to fill out the lead made at the request of the Massachusetts DEP, I think that certainly follows that case law there.
Good.
Good.
Anything else we can think of?
Just want to go through attorney on that. I just was going over one of Attorney Armand's letters to see, I think we covered some of the same grounds he covered, from a different perspective, though. No, I have nothing else to add, just wanted to double check.
Better, Bob?
Yeah, I mean, this doesn't have as much to do with the pistol location, but if you were discussing the sound issue at all, there was an affidavit from Scott Bowker just denying any statements he made on conclusions of noise sounds from firearms. And one of Mr. Ahmed's letters used that as a noise comparison.
Is that factual for whether the rifle range was there or not?
Well, no, I'm just saying that you mentioned a noise
Pistol
situation.
range.
This is just something that's just saying that the statements that were made on his behalf weren't his conclusions.
And that's relative to the pistol range.
Yeah, we can think of noise in general, be relative to both.
But I think,
His statement is in here.
Yeah.
Yeah.
I thought there was something that said they measured sound at their home.
There was something submitted by Attorney Ament, I believe, that came up like 92.
92, 94.
96, something like
and
that.
Since we weren't, I apologize, I didn't bring that up until you just brought it up, but I don't know how you say it diplomatically,
But that was noise. We don't, was that pistol, was that rifle?
I wish I could ask Mr. Amant to clarify any question. I'll see if I can find it. Can I ask him a clarifying question? No. So, okay.
It's up to the board.
Well, if the board doesn't want to ask it, I remember distinctly reading that when I was trying to choose between adverse impacts and non-adverse impacts. Then it slipped away from me.
I'm trying to help you out, Jerry. I have some PDFs here that I'm trying to go through.
Was it on this one regarding the muzzle brakes?
It might have been, it was
It
clearly
was a
from,
September, was it September or November, I remember.
November 7th.
You've got the file.
I got September 21st. Let's see.
November 7th.
Is it November 7th file?
So that's what I took this one from.
There's some of the attachments. I'm not sure it's, it's significant because we're not talking about noise and adverse impacts. You know, that'd be another whole round of sound measurements and testimony and public health. So I guess maybe I'll withdraw that.
Okay.
On Michael D'Souza's, on Michael D'Souza's affidavit, I think it's listed on Exhibit B with Attorney George. He does notate the 3 aerial photographs that were included in that packet. And it says the 1971 aerial clearly shows that the rifle, pistol, and trap ranges were already well established in the club. And they attach the photographs taken over Midway Trap and Ski Club in 1966, 71, and 94.
That's his affidavit that we have listed already, right?
Yeah,
Yeah.
but it refers to those other photographs that were submitted,
Right.
66,
Those are-
71, and 94.
Right.
But does that lead us down a slippery slope as to what photographs we accept and what photographs we don't accept?
Well, it's a photograph that just at least shows that there was a pistol range in existence.
It's his affidavit.
It's his okay, that's different, it's his
Spelled out
affidavit.
item number 13 in that.
Okay, all right.
Still looking for something, Jerry, or?
No, I took it off the table, it's just
Okay.
my own. I do recall that.
All right, this last call, does anyone else have anything else to add?
No, I think,
I think that's it.
Okay. Well, since we all seem to agree to overturn the building commissioner's cease and desist order, I'll take a motion to that effect.
I'll make a
I'll
motion.
entertain a motion.
I'll make the motion to overturn 067-17.
Okay, motion was made by Ed to overturn the building commissioner's decision regarding the cease and desist order for application 67-17 Midway Trap and Skeet. Is there
That a
s-
pistol range did not exist.
That a pistol range did, I'm sorry, just trying to make sure we get this right.
Yeah.
That the pistol range did exist.
Right.
No, you're overturning his determination that
Right.
that a
It did
pistol
not.
range did not exist.
Overturning his decision that the pistol range did not exist.
Did not exist. But we find it existed. I mean, maybe that's double,
Yep.
Little double
that's
step.
all right.
Jerry, sounds like you might want to,
I'll second
Second
it,
it.
sure.
okay, motion was made by Ed, second by Jerry. All those in favor?
Aye.
Aye.
Aye. Okay, that's a unanimous decision. Thank you.
We
I
have no
need-
meeting tomorrow night.